So in our previous video on Companies Act, we had discussed all the different types of companies, and the rest of the companies, whatever was there in CA Foundation, that syllabus was pending. So in our today's discussion, we are going to discuss whatever was left. But before that, let us just do a very small recap of all the type of companies that we had discussed, so that whatever you have studied or whatever you have actually understood there, we are able to just, we are able to recap everything. So we had started with what is a company? A company means a company which is registered under this act or previous act. So if it is registered under this Companies Act or any other previous Companies Act, it's considered as a company. So one thing that was very clear from this definition was that unless it is registered, a company is not incorporated. On incorporation, on such registration, the company acquires certain features. The most important feature is separate legal entity, which in fact gives all the other characteristics of a company. The next other characteristics are it has limited liability, it has perpetual succession, that is the death of a member does not result in the death of the company. It has a right to sue in its own name and a right to be and also a liability to be sued in its own name. Then again, it may have a common seal. The property of the company belongs to the company itself, and the management of the company is separate from membership or ownership. Then we had discussed the different types of company. First is limited by shares, that is the member shall be liable for the unpaid value of the shares held by them. Then what is limited by guarantee? The amount a member undertakes to contribute to the assets of the company in the course and for the purpose of winding up of the company. Unlimited liability, there is no liability or there is no limit on the liability, that is the members will be liable without any limits. Now the next one is OPC. What is OPC? Which has only one person as a member. I've already told you all the rules relating to an OPC is given under the company's incorporation rules. So as per the company's incorporation rule, only a natural, the first point is only a natural person. Natural person means you and me. I've already told you in law, the word person does not just mean you and me, artificial persons are included. But for an OPC, only a natural person who is an Indian citizen, and a resident. Just an Indian citizen isn't enough. Along with being an Indian citizen, he should also be a resident of India. What is resident of India? Has stayed in India for at least 182 days. That is for not less than 182 days in the immediately preceding financial year. Can be a member or a nominee of an OPC. Nominee, we mentioned the name of a nominee in the memorandum. The whole purpose of this nominee is that tomorrow, if anything happens to the member, he is dead or he is incapacitated, this nominee shall automatically become the member of the OPC. But before I name anyone, I should take that person's consent. I cannot just name anyone without that person's consent. So his consent shall be taken. He can at any time withdraw his nomination. Similarly, the member can change the nomination. So how many companies, how many OPC can I be a member or a nominee? At the same time, I can be a member of one, only one, and at the same time, I can be a nominee of another OPC, but not more than one. So only one OPC I can be a member and at the same time nominee. So in this case, if at any given point of time I become a member of more than one OPC, and that can happen only because of one reason, and that is because of nomination, then in that case within 180 days I have to select any one OPC. I have to leave the other OPC, select any one OPC. There are certain restrictions on an OPC. A minor cannot be a member or a nominee of an OPC. It cannot register as a Section 8 company or on a future date convert into a Section 8 company. And this OPC cannot carry on a non-banking financial activity. It cannot invest in the securities of any body corporate. And the paid up capital can never exceed 50 lakhs, and the turnover of such company, average annual turnover for the relevant period means last 3 years, cannot exceed 2 crore. So these are the restrictions, and further there is one more restriction. If an OPC wants to convert into a private or a public company, it can do so, but only after 2 years of incorporation. That is, if by choice it wants to convert into a private or a public company, it cannot do so at least for 2 years from incorporation. But at any given point of time, if the paid up capital exceeds 50 lakhs or the turnover, average annual turnover exceeds 2 crore, it has to. There is no choice here. You have to convert. Another thing, can an OPC convert into a Section 8 company? No, we have already seen that it's a restriction. The next one, private company. A private company is one which has a minimum paid up capital which may be specified. I've already told you what that means. And by its articles. So the articles of every private company must have these restrictions. What? restricts the transferability of shares. Restricts, okay, don't use the word prohibit. Restricts the transferability of shares except in case of OPC, limits the number of members to 200. However, in case of 200 members, we count joint members as one, and any person who is an employee of the company or any person who was an employee took the shares while he was an employee and still continues to hold them. That is, ex-employees who took the shares while in employment and continues to hold them. These two people are excluded. And the last one, prohibits the issue of securities to the public. It's securities, not shares. Prohibits the issue of securities to the public. Public company means a company which is not a private company, has a minimum paid up capital as may be specified. Now, if a private company is a subsidiary of a public company, if a private company is a subsidiary of a public company, not going into the details because I've already explained all of this in the part 1 revision. If a private company is a subsidiary of a public company, then for the purpose of the act, it shall be considered as a public company. That means restrictions will be there. So when I say it will be considered as a public company, doesn't mean the restrictions will not be there. The restrictions will be there, but the act will apply as if it is a public company. In its articles, still it is a private company. It will still have those restrictions, still has to use the word private, still cannot issue securities, still number cannot be more than 200. But the law will apply on it as if it is a public company. A small company is a public company. So a small company means any company other than a public company, which has a paid up capital not exceeding 50 lakh, the same figures as OPC, 50 lakhs or such higher amount as may be specified, not exceeding 10 crores, and turnover as per this is not same, as per the profit and loss account of the immediately preceding financial year. There it was average of the past 3 years. Here it is previous financial year, preceding financial year profit and loss account. Does not exceed 2 crores or such higher amount as may be specified, not exceeding 100 crores. Small company enjoys certain benefits. So even if a public company fulfills these restrictions, it can never enjoy those benefits. This clause does not apply in case of a holding and a subsidiary. So if a holding and a subsidiary, either of them have these, they fulfill these conditions, no matter, however, whatever, if they fulfill the conditions, no matter what, they will not enjoy the privileges of a small company. Then Section 8 company and a company which is governed by a special act. The next one, holding and subsidiary. Holding subsidiary, a company is said to be the holding of another if such other is its subsidiary. So that basically this definition itself tells us that it's a very circular relation. That is, if I am your holding, you're automatically my subsidiary. Subsidiary, if you fulfill any one of the two conditions, you will be considered as a subsidiary. Control the composition, that is the right to appoint or remove the majority of the directors, or hold more than half of the total voting power. Please understand, it's not total share capital, it is total voting power. That is, holds or controls more than half of the total voting power. Here, this, I guess, I don't know if I had told in the previous video or not. In this case, they had added an explanation. For the purpose of this clause, the word company includes a body corporate. Now, what do I mean by body corporate? A body corporate is a wide term. See, when I use the word company, the usage of the word company means I'm only talking about the company which is registered under the Companies Act. But when I use the word body corporate, I am talking about any company, whether Indian or foreign. So, for the purpose, that means here they have used the word company. This includes even a body corporate. Here they have used the word company. This includes even a body corporate. So, if let us say one company is Indian, one is foreign, still they would still have the holding subsidiary relation. And layers, that is, if I am your holding and you are someone else's holding, I am automatically their holding. If I am your holding and you are someone else's holding, I am automatically their holding. However, if the shares are held in a fiduciary capacity, for example, as a trust, I am holding the shares, a company is holding the shares as a trustee. So there, the company is not holding itself the shares, but it is holding because it is a trustee. So those voting powers cannot be counted for these voting powers. So, if the shares are held in a fiduciary capacity, that shall not be included. So, the next one, associate company. I am your associate if you have a control over me, if you have a significant influence over me. So, if there are two companies, you have a significant influence over me. If there is company 1, company 2, company 1 has a significant influence over company 2. Company 2 is the associate. If company 1 is there, company 2 is there. If company 1 has a significant influence, obviously who will be the associate? Company 2 will be the associate. What is significant influence? At least 20% of the total voting power or business decisions. And even here, shares held in fiduciary capacity shall not be included or shall not be considered. Government and foreign, where at least not less than 51%. Please understand, in holding it was more than half. Here it is at least 51% of the shares are held either by the central government or the state government, or both of them together. What is foreign company? Incorporated here or here, outside having a place of business here. So which is incorporated outside India but has a place of business in India. The place of business can be direct or through an agent. The next one, listed and unlisted. Listed company whose shares are listed at the stock exchange, unlisted whose securities are not shares, rather securities are listed at the stock exchange. Because we have a definition for listed, unlisted comes from that definition. It's not defined under the Act. What is unlisted? Which does not have the securities listed at the stock exchange. Section 8 company, non-profit organization which is formed for the object of promoting science, sports, arts, religion, commerce, technology, environment, anything. Not all of them, anything. First, so what is the first? What is the objective? The objective is to promote science, sports, arts, religion, commerce, technology, charity, anything. They do not distribute dividend. So will they distribute dividend? No, they do not. So what do they do with the profit? They reinvest that profit into the business to promote its object. So they have to apply to the central government for the license. Once the license is issued, it becomes a Section 8 company and it does not have to use the word limited or private limited after its name. But see, whenever a license is issued to you, it can be subject to a condition, or you have to fulfill these objectives. If the company fails to fulfill these objectives, what will happen? The license will be revoked. What will happen? The license will be revoked. And once the license is revoked, 3 consequences can arise. Not all of them, any one. What? If the license is revoked, either convert into a private or a public company. If you convert into a private or a public company, you have to add the word limited or private limited after your name, and you have to inform the registrar. Then second, what you have, either or the company may be ordered to amalgamate with another Section 8 company, or the company may be simply wound up. So these are any of the 3, but before anything is done, an opportunity of being heard, that is, the company should be given the right to speak before any order is passed. A dormant company which is formed for a future project or to hold an asset or intellectual property. So the company is not going to work today. The company is going to work on a future date, or they are just holding an asset. But the status of a dormant company can be only for 5 years. You cannot be a dormant company for more than 5 years. So such company is regarded as a dormant or an inactive company. Such company shall have no significant accounting transaction. And what is significant accounting transaction? Anything other than this: payment of fees to the registrar, payment of anything which is required by any act, payment for maintenance of office or records, or payment for allotment of shares to meet up the requirements of the act. Like for example, the subscribers minimum 1 share they have to take up. So if you are allotting the shares, that is because to meet the requirement of the act, that is not considered as a significant accounting transaction. Nidhi company, the basic idea of a Nidhi company is to inculcate the habit of saving amongst the members. So the whole point is that they want to incorporate the idea or the habit of saving amongst its members. Public financial institution in which not less than 51% of the shares is held by or controlled by the state government or the central government, or both of them. It has been special or it has been enacted or constituted under the Special Act. As of today in India, we only have 3 public financial institutions. So what are these financial institutions? LIC, Life Insurance Corporation, IFDC, Infrastructure Finance Development Corporation, and UTI, Unit Trust of India. So these are the 3 financial institutions as of today that we have in India. Now, incorporation of a company. How is a company incorporated? Obviously, there is a procedure. Because I have to get the company registered, there has to be a procedure. So what is this procedure? Now please understand, you would find it in section 7, that this is given in section 7. Apart from this, the first 2 points are given under the company's incorporation rules. The first 2 points are given under the company's incorporation rules, and the rest is all in section 7. So section 7 read with company's incorporation rules, what it tells us. So first thing, I have got an idea to incorporate a company. So what I am going to do is I am going to keep a name for myself. So I under RUN, reserve unique name, I am going to apply for names. In order of preference, I will apply for name. Now in the next one is in INC 32, the application for incorporation is given in INC 32, also known as SPICE, Simplified Proforma of Incorporating Companies Electronically. So what applications I give in this INC 32? In this INC 32 we can make 4 applications. First, application for incorporation, that I want to incorporate my company. Then availability of name. Ma'am, we have already done it through RUN. Well, if you have already done it through RUN, you can use that name. If you have not done it through RUN, you can directly do it in INC 32, that is SPICE. So application for name. Then appointment of directors, but only maximum 3, and then last appointment allotment of DIN. DIN, director identification number. If a company wants to, if a person wants to become a director of a company, he must hold a DIN. So all these 4 applications are made in INC 32. Then along with this INC 32, we have to give certain documents. What are these documents? First, electronic MOA AOA. But if there are more than 7 subscribers, we cannot give electronic MOA AOA, it has to be the paper form. Then a declaration by persons engaged in the formation of the company. Who is this person engaged in the... See, when I incorporate a company, I take a professional help from a professional like an advocate or a chartered accountant or a cost accountant or a company secretary in practice. So, not all of them, any one I appoint. So, that person who I have appointed, that person shall give a declaration and. So, anyone who I have appointed, that person and person named in the articles as director, manager or secretary, anyone, not all of them. So, one declaration from this person and one declaration from either director or manager or secretary. What declaration? That we have fulfilled all the requirements of the Act for the incorporation of a company. So, I repeat again, what are the documents which are filed with INC 32? First, I file an EMOA AOA. Second, I file a declaration. Who will give this declaration? Any professional who is engaged with the incorporation. Who are those professionals? Either an advocate or a chartered accountant or a cost accountant or a company secretary, and a person who is named in the articles of the company as a director or manager or secretary. What declaration? That we have fulfilled. We have fulfilled all the requirements of the Act for the incorporation of the company. Again a declaration. Now here it is each subscriber. Here it was any one of them will give. But here each subscriber and each person who is named subscriber, when we sign the MOA, these people are known as subscribers. So these people have to give a declaration, and every person who is named as the first director of the company shall give a declaration. What? That we are not guilty of any offense. It will be not guilty of any offense in the incorporation of any company. Second, we are not guilty of fraud. It will be not guilty of fraud or breach of duty in the management of any company. Obviously not this company, but ऐसा नहीं है कि you can be a director or subscriber of only one company. You may be a director or subscriber of other companies too. So this declaration is given for the other companies, that while I was incorporating some other company, I was not guilty of any offense. Guilty of offense, when we come towards the end of section 7, there you will see that if I have given any wrong information, I am guilty of offense. It's an offense that I have committed. So I have, in the incorporation of any other company, I was not guilty of any offense. Second, I gave a declaration that I was, while managing some other company, I was not guilty of fraud. I have not done any fraud, or I have not done any breach of duty. Breach of duty, I have done whatever was authority was given to me, nothing less, nothing more. In the past 5 years, both in the past 5 years. And the third declaration, that all documents given as per my knowledge, all documents given as per my knowledge is true and correct. Whatever documents we have filed, as per my knowledge, it's true and correct. So first declaration is given by a professional who is engaged in the incorporation of a company, either an advocate or a chartered accountant or a cost accountant or a company secretary in practice, and by any one person who is a director or manager or secretary, that we have fulfilled all the requirements of the Companies Act relating to incorporation of the company. Second declaration is given by every subscriber and persons who are named as first directors in the articles of the company, who are named as first directors. What? That we were not guilty of offense in the incorporation of any company. We were not guilty of fraud or breach of duty in the management of any company in the past 5 years. And all information given or all documents filed as per our knowledge is true and correct. Then for correspondence, I have to give an address. So if I have a registered office, I've already taken a registered office, that address. If I don't have a registered office, then wherever I am going to take the correspondence from the registrar, that address has to be given. Then details of the subscribers. What details of the subscriber? Name, family name, surname, occupation, address, identity proof. And if the subscriber is a body corporate, can a body corporate be a member of another company? Yes, I had told you in the previous video. So in that case, certain other details are required. In case again I need the details of the directors. What details of the directors? Their name, same name, surname, address, occupation, identity proof, and yes, in case of a director, I also need the DIN. Now, my director can also be a director of any other body corporate, or he can be a partner of a firm. So such declarations, a declaration of his interest in any other body corporate or firm, and his consent to act as director. Very important. Otherwise, someday someone will appoint you as a director, you don't even know, and you have not done anything. Suddenly the police comes to arrest you. Sir, you have done an offense. Where? In the company. I was not even a director. I am not even aware. So it is important. So last, interest of the director in any firm or body corporate and his consent to act as a director. When we file all this with the registrar, and if the registrar is satisfied that we have fulfilled all the requirements, the registrar will issue a certificate of incorporation. This certificate, and he will allot a SIN. But if he feels that some informations are missing, he can ask for refiling. Maximum refiling 2. Maximum days of refiling each is 15 days. Total refiling should be done within 30 days. So I repeat again, if the registrar feels that the information given is not up to the mark or is incorrect, then in that case, what the registrar can do is the registrar can ask us to refile. Within 50 days, we should resubmit with the corrections. Maximum resubmission 2. Maximum time for the total resubmission is 30 days. I hope the incorporation part was clear to you all. Now, if I am incorporated by giving false or incorrect information, what happens in that case? If the company is yet to be incorporated, every person who signed that document means the incorporation document, and knew that the information is incorrect, will be liable under section 447. Though you don't have to do section 447 in details because that's not there for you right now, but just in a gist I'm telling you, I mean just a glimpse of that section so that you know it is so harsh that the punishment can go up to 10 years also. If the company has been incorporated, then since the company is not incorporated, in the previous case only the persons can be punished. But since in the second case the company is incorporated, the persons who have signed, the promoters, the persons who are named as first directors, and the persons who have made declarations under the act, shall each of them be liable under section 447. Section 447 is actually for fraud. And for the company, the tribunal can pass any of the following orders, but after giving the company an opportunity of being heard. That before the company shall have a right, before any order is passed, the company shall be given a right to speak. What can be the orders? Any orders for the management of the company. It can make the members' liability unlimited. It can pass an order to strike off the name of the company. It can pass an order for the winding up of the company. Apart from this, an open-ended point. Apart from this, if the tribunal feels I can pass something else apart from these 4. So they always keep an open-ended point. The last point, if we feel anything other than these 4 also, so that order is also, he has a right to pass. So if the company is incorporated by giving false information or giving information which we know is not correct, then every person, if the company is not yet incorporated, the person who has signed the document and knows about it shall be liable under section 447. If the company has been incorporated, then obviously the person who is the promoter, the person who is named as the first director, and the person who gives declaration, advocates, CA, CS, remember, liable under section 447. Apart from that, for the company there is a separate liability. The tribunal can pass any order What orders? Any order for the management of the company, an order to make the members' liability unlimited, an order for the striking of the name of the company, an order for the winding up of the company, and one open-ended point, any other order it deems fit. Now, once the company is incorporated, we already know the concept of separate legal entity comes into the picture. What is separate legal entity? We have already discussed. However, there are certain cases where this concept of separate legal entity is ignored. What is this concept of the wheel is lifted or it is ignored? That means the members are liable for the acts of the company. We know the members have no liability, right? The members have no liability for the acts of the company, but when the wheel is lifted, the members will get a personal liability for whatever the company does. So now we are going to discuss what are the cases where the wheel is lifted. So the first case was protection of revenue. You know, actually in this lifting of corporate wheel, that is where the wheel is ignored, the wheel is pierced, and the members are personally liable for whatever the company does. As such, you will find there are no such sections except a few, like we had just discussed section 7, where the member is personally, the court, the tribunal may make the member personally liable. Apart from that, you will, and there are a few more sections which is not there in your syllabus, so not going into that. But then otherwise, generally there are judicial cases on the basis of which the wheel is lifted. The first one, protection of revenue. The name of the case was Sir Dinshaw Manikji Pettit, and there was another similar case, Jugilal versus Income Tax Commissioner. In this case, what happened was, just to protect the payment of revenue, just to protect or to avoid the payment of taxes, this person had formed 4 companies. The court held the only purpose for forming all of these 4 companies was to avoid the payment of taxes, and the wheel was lifted. And when we say the wheel was lifted, it means what? The member was asked to pay, the person was asked to pay the taxes to the government. The next one, company is a sham or a fraud. There were 2 cases in this case. One was Guilford Motor Company versus Horn, and the other one was Jones versus Lipman. In Jones versus Lipman, there was a contract to sell land. Later, the seller did not want to sell the land, so he made a company and sold the land to that company. You would say why? He could just avoid it. Sale of land is a contract where specific performance can be granted by the court. But if you have already sold the goods to some other person, then court cannot grant you specific performance. So if A would still have the possession of the land and ignore to or refuse to sell it to B, B could get an order for specific performance. But if A sold it to another person, B couldn't get an order for specific performance. So just to avoid the sale of land, he formed a company and sold this land to the company. The court held that the only purpose for forming this company was to avoid the sale of land. The wheel was lifted. And when we say wheel was lifted, means what? The person, the seller, was ordered to sell the land to the buyer. In Guilford Motor Company versus Horn, the employer made a contract with his employee that he cannot enter into a contract with the employer's clients. Now, this employee, to contract with these clients, formed a company, and through this company started contracting with the clients. The employer stopped him. He said, you asked me not to contract with the clients, not the company. Company has a separate legal existence. The court held the only purpose to form this company was to avoid the, to contract with the clients of the employer. The wheel was lifted. And when we say the wheel was lifted, means what? The employee was asked not to contract with the clients. Then the next one, where the company is formed to avoid welfare legislations. The name of the case was Associated Rubber Industries Limited Bhavnagar versus the Workmen of Associated. It is Workmen of Associated Industries Rubber Limited Bhavnagar versus the Associated Industries Limited Bhavnagar. One thing is Associated Rubber Industries Limited Bhavnagar. One thing is very clear from this case was that it's a contract. It is a case between the employer and employee. What happened was the employer was earning huge profits, and when you earn huge profits means you have to pay huge bonus. So and the company did not want to pay. So the company formed a subsidiary company and transferred a chunk of the investment from where the income was coming. Later, obviously the employees did not like it, so employees filed a case. The court held that the purpose of forming this subsidiary company was only to avoid the payment of high bonus. So the wheel was lifted, and when we say the wheel was lifted, means the employer was asked to pay the higher bonus. The last one, to determine the true character of the company. As in, here you will find in all the first 3 cases, what we saw was that the company has done something wrong. In all the first three cases, what we saw was that the company has done something wrong. But in the fourth case, the company had actually not done something wrong. There was nothing wrong. But just to determine whether the company is an enemy company or not, the wheel was lifted. The name of the case was Daimler Company Limited versus Continental Tire and Rubber Company Limited. In this case, a company was incorporated in England, but it had 90% of the Germans. However, because member and company is different, we would say it's an English company. During World War I, English and Germans, they were at war. So the company filed a case against the English debtors. So they refused to pay. So when the case went to the court, the debtors were asked, why are you not paying? They say, we would be ready to pay, but it's an enemy company. The company is an enemy person. So the company said, how can we be enemy? We are formed in England. There the court held that since the company, though it was incorporated in England, 90% of the shareholders were German. Now, generally, company and members are different. But here, to determine whether the company is an enemy company or not, the wheel was lifted. And when the wheel was lifted, it was found that 90% of the members were German. And since German and England, they were at war, it was held that the company is an alien enemy. You must have done that, and you have studied that in Indian Contract Act. Alien enemy, the contract is void. Held, the company cannot sue the debtors. I hope it's clear to everyone. The next one, Doctrine of... Now, we already know we have these two important documents of the company, which is MOA and AOA. MOA is the charter of the company, tells us the whole existence of the company, why the company is existed. So, one of the clauses of this memorandum is an object clause which tells us what the company can do. And when it tells us what the company can do, rest everything the company cannot do. So, if anything is entered into which is against the MOA, we call it as ultra vires. The whole thing is that the MOA tells us what the company can do and the AOA tells us how the company will do it. So when the company does any act which is against its object, such an act is ultra vires. Ultra means beyond, vires means powers. It is beyond the powers of the company and such a contract is void. However, if it is ultra vires the AOA, it can be ratified. We already know what is ratified. Future acceptance with a retrospective effect, right? So when we say ultra vires the AOA, it can be ratified, but when we say ultra vires the MOA, it cannot be ratified. So what happened in this case was, in the case of Ashbury Railway Company versus Ritchie, this company was incorporated with the following objectives. What? To sell, lease or otherwise give on hire railway carriages, to do the work of, carry on the business of mechanical engineers and general contractors, and to purchase, lease and sell work mines. Now, this company entered into a contract with Ritchie to give a loan. So, however, later the MD realized that this giving of loan to Ritchie was against the objects of the company. I repeat again, this company was incorporated with the object to sell, lease or otherwise give on hire railway carriages, work mine, and to carry on the work of mechanical engineers and general contractors, and to purchase and sell agents or as merchants or agents coal, timber, metal, etc. So they were into buying and selling of coal or metals or timber or railway carriages or work mines. I mean work mines only to give on sell or lease or purchase. So they were into this work. Now this company entered into a contract with Ritchie to give a loan to Ritchie. Later the MD realized that this loan that they were agreeing to give to Ritchie was not given in the object clause. So they asked Ritchie, they informed Ritchie that we are sorry Mr. Ritchie, we are not supposed to do this, so we cannot give you this loan as it is ultra vires the MOA. So Ritchie said, no, see, you have no general contractors. So since you are general contractors, you can give us the loan. So in this case, then the MD said, sorry, we cannot, the MOA doesn't allow. So Ritchie said, I'll sue you. So they filed a case. The court held, applying the rule of ejusdem generis, when we say general contractors means anything which relates to mechanical engineering. When we say general contractors, applying the rule of ejusdem generis, general contractors means anything to do with mechanical engineering. In this case, what has happened is that they have agreed to give a loan, and loan is not something which relates to mechanical engineering. So the court held that the contract is void. And in fact, even if the company calls all of its shareholders and says give the consent for this loan, it is not valid. So ma'am, they can never give a loan. They must first amend and then give a loan. Here, without amending, they are giving a loan. This cannot even be ratified. So any contract which is ultra vires is void ab initio. Even the whole body of shareholders cannot ratify it. However, if it is ultra vires the directors but intra vires the company, that means the directors can do it only with the consent of company, that is with the consent of members. But without the consent of members, they do it. Then in that case, it can be ratified. Simple. If the directors, just a hypothetical case, if the directors want to give a loan, they must get the consent of the shareholders. They gave the loan without the consent of the shareholders. So this is something that the company can do, but the directors have no authority. So the directors act can be ratified by the company. So anything which is ultra vires is void ab initio. Even the whole body of shareholders cannot ratify it. So if it is ultra vires the MOA, it cannot be ratified. But if it is ultra vires the AOA, it can be ratified. Now you would say, ma'am, how is Richie supposed to know? How is Richie supposed to know whether the company can do this or not? Come on, ma'am, that is company's document. Company should know. How will Richie is going to do some stealing or something? You don't have to be so dramatic. What section 399 says is, if you remember, when I was teaching you incorporation, I told you the company has to file its MOA and AOA with the registrar, correct? The company has to file its MOA and AOA with the registrar. Whenever I file MOA or AOA with the registrar, these documents become a public document. These documents become a public document and it is deemed, please understand, it is doctrine of constructive notice. Constructive notice, I am not telling you about it. I am not asking you about it. I am under the impression that since you are contracting with me, you know about it. This is constructive notice. It is not a real notice. I am not going to ask you. I am just under the impression that since you are coming to contract with me, I deem that you know about it. So, whenever I file my documents with the registrar, they become a public document. And it is deemed that every person dealing with the company has knowledge about it. So basically what this doctrine does is it protects the company against the outsiders. That is, the outsiders cannot come and claim, oh my god, I did not know about your MOA. It was your duty to know about my MOA. You cannot come to me and claim anything. You cannot come to me and claim anything. It is my impression that since you are dealing with me, you know about it. This is doctrine of constructive notice. So basically, we can say that this doctrine protects the who? The company. This doctrine protects the company. Now, further, we have a protection for the company. So we should also have a protection for the outsiders. The next doctrine, the doctrine of indoor management, what it says is, indoor management, what is going on inside the company is not the concern of the outsider. What is going on inside the company, how they are supposed to do, whether they are doing it or not, is not the concern of the outsider. I just have to know whether the company has a right to do it or not. How that right is given, or whether the right is given to them or not, is not my concern. I just have to know whether the person who is there representing the company, does he have the authority to do it or not. I am not liable, or I have no obligation to go and see whether that was fulfilled or not. The indoor management was, see, simple. You go to the ICI, that lady or the person, whoever is sitting in the office, you pay the fees to them. You are only liable, your duty is only to know whether that person has the authority to collect that fees or not, or to collect that form or not. Who gives them the authority is not your concern. So your concern is only to see whether that person who is sitting at the ICI office, does he have a right to collect your documents or not. How that right is given, we don't have to see. Ma'am, how will I know whether he has a right to collect or not? The fact that he is sitting in the office means obviously he has a right to collect that form. But how he gets that right is not my concern. So, what doctrine of the most important case for this was the Royal British Bank versus Turquin. Here in this case, the concept of indoor management was laid down. What it says is that the outsider should know whether the company has a right or authority to do that work or not. How that right or authority is given is not the concern of the outsider. So basically, where constructive notice was protecting the company, indoor management protects the outsiders against the company. Indoor management protects the outsiders against the company. Now, in this case, the Royal British Bank versus Turquin, what happened was that this company had a right to issue bonds. But to issue these bonds, they needed the consent of the shareholders. Royal British Bank, they took the bonds. But the company had not passed that resolution. Now, when later Royal British Bank claimed the money, the company said that we are not liable to pay you the money as the shareholders' consent was not taken. Can they refuse? I repeat again, there is this company which had a right to issue bond. But this right to issue bond was only when the shareholders' consent was taken. They issued bonds to the bank without the consent of the shareholders. So when they issued the bonds without the consent of the shareholders, later the bank claimed the money, they refused to pay the money, saying that the shareholders never gave the consent. Now, me as an outsider, my duty is to know whether this company has a right to issue the bonds or not. That Royal British Bank had checked. How they got the consent, whether the shareholders' consent was taken or not, is it the consent of the outsider? No. So when I am talking about outsider, my duty is to see whether the bank has the right or not. I don't have to see how that right is given. So the bank will get his entire money or not? Yes, because it was not the duty of the bank to check the internal management of the company. लेकिन लॉ में क्या होता है? लोचा. So obviously यहाँ पे भी कुछ लोचा है. There are some lochas which do not apply to the case of indoor management. Tell me, if you are a part of the management, if you are a part of the management of the company, you will know what is going on. Can you go and say, oh no, I don't know? How can you? When you have the knowledge of irregularity, how can you claim any relief? When you have the knowledge of irregularity, how can you claim any relief? Negligence. You could actually, by using your diligence, find out whether it was done correctly or not. The accountant telling you, I'll sell the property of the company. The accountant only has a right to prepare the books of accounts, not to sell the properties. You agree to purchase. Can you go and say indoor management? No. You were negligent here. That you did not bother to check how can the accountant sell the assets. So it was negligence. Can you say indoor management? No. See, forgery is something which is a nullity. When I give my genuine signature, something is valid. But when my signatures are forged, it is from its inception not valid. So in case of forgery, you cannot go and claim any relief at all. You would say, but ma'am, I am also an ignorant and innocent party. Yes. Even though you are an innocent party, forgery will not give you any relief. So let's say any officer of the company forges the signature of another officer. Can you claim any relief? No. Here, though you are an ignorant party, you will not get any relief. You cannot say indoor management. No. But ma'am, I am innocent. Yes, you can file a case against that person who has committed the fraud against you. But you cannot claim anything from the company. Forgery does not give any relief. So forgery is basically copying someone else's signature. So in this case, when we say forgery, even though you are an innocent party, but because forgery being null and void from the beginning, you will not get any relief. Wow. Constructive notice says you must have knowledge. Ayo, I did not know. Leave me this time. Next time I will know. Can you claim any relief? No. If you are ignorant about the MOA, AOA, you cannot claim any relief. So, I hope the doctrine of indoor management is clear to everyone. With this, we have completed all the entire part. I mean, I'm not going into the shares, what are the different types of, you already know that. With this, we have completed the entire Companies Act. I hope it helped you. If it did, do leave a like and comment. All the best for your exams. Your paper should be as lit as you are. And happy learning and stay motivated. Thank you so much.